Hello, and welcome to UK Employment Law, the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners, which highlights recent case law and legal developments of importance to UK employers. It is presented by members of Mayor Brown's employment team and occasionally features special guest speakers who are involved in changes in employment law. The time spent listening to these podcasts can count towards your continuing education requirements. And at the end of the podcast, we will explain how to get in touch if you wish to claim credit for continuing education purposes or if you have any comments or questions. We hope you enjoy the podcast.
Hello and welcome to the Mayor Brown Employment Podcast. I'm Chris Fisher and I'm the head of the employment team at Mayor Brown in London. I hope everyone's well. I thought we'd have a break from COVID-19 cases this time, and instead we've got two discrimination cases for you, one from the Court of Appeal and one from the EAT. The first one looks at whether our discrimination law will be amended to allow interim relief remedies, and the second looks at whether gender-critical beliefs can be protected as philosophical beliefs under the Equality Act. So starting with the interim relief case from the Court of Appeal, and that's the case of Steer versus Stormshaw. Now, we've been following this case closely because of its potentially huge significance. At the end of last year, the EAT ruled that our Equality Act was not compatible with the European Convention on Human Rights because it discriminates against people dismissed for discriminatory reasons when compared with people dismissed for blowing the whistle. In a whistleblower dismissal case, the claimant can apply for interim relief, but in a discriminatory dismissal case, they can't. Interim relief in a whistleblowing case is a massively powerful remedy if you are awarded it. If the claimant can show a good chance of winning their claim, then the court can order the employer at the very beginning of the claim, once it's issued, to continue employing the employee until the claim comes on for hearing, or more commonly, to continue paying them if the employer doesn't want to re-employ them. Now, if the employee loses their case when it ultimately comes on for hearing, then they don't have to repay any of the earnings that they've received in the interim. So, in Steer and Stormshaw, Ms. Steer claimed that her dismissal was discriminatory on grounds of sex and applied for interim relief. The tribunal, not surprisingly, said that they had no power to grant interim relief for a claim of sex discrimination under the Equality Act, and so she appealed to the EAT. She argued that under Article 14 of the European Convention, which prohibits discrimination, an interim relief remedy should be available in sex discrimination dismissal cases, as it was for unfair dismissal cases involving whistleblowers. And the EAT agreed that this was indeed a breach of the European Convention as they saw it, but the EAT didn't have the power to declare the UK law incompatible with European law, and so it granted leave to appeal to the Court of Appeal. Now, the Court of Appeal disagreed with the EAT and it rejected the claim. First of all, it said that there was no basis to claim breach of Article 14 simply because the UK sex discrimination law did not have a remedy that the UK whistleblowing law provided. That did not amount, they said, to sex discrimination. Otherwise, the court said, sex discrimination claimants could compare the discrimination remedies available with remedies available in any other employment law claim that is brought equally by men and women. So that actually dealt with the claim, but the court went on to say that in any event, they didn't think that discrimination claimants were treated less favourably than whistleblowing claimants. They acknowledged the power of an interim relief remedy, but they said that if you look at the package of remedies available in a discrimination claim, when compared to an unfair dismissal whistleblowing claim, then discrimination claims were in fact more favourable in a number of ways. For example, the time limits for bringing discrimination claims, where the tribunal can extend time if it considers it just and equitable to do so, whereas in an unfair dismissal claim, an extension of time is only given if it's not reasonably practicable for the claim to be put in on time. And then there's also the reverse burden of proof in discrimination claims, which doesn't exist in unfair dismissal claims. And finally, the fact that the threshold test for a whistleblower dismissal case is the claimant having to show that the protected disclosure was the reason or the main reason for their dismissal. Whereas in a discrimination claim, the claimant only has to show that the protected characteristic was an effective cause of the dismissal. So that was Steer and Stormshaw. And although we thought we might see a seismic shift in employment litigation in the UK if interim relief had been introduced into discrimination claims, it doesn't look as if that's going to be the case. Having said that, at the end of the judgment, the Court of Appeal did acknowledge that there was a problem for discrimination claimants in terms of the length of time they sometimes have to wait for their hearings to come on. And certainly that's a particular problem at the moment with the COVID-related delays we're seeing in the tribunals. And the court suggested that government may want to consider introducing some form of interim relief for unfair dismissal claims, or at least for unfair dismissal claims that involve discrimination. We'll see if Parliament decides to do that, though I think at the moment introducing what would amount to a significant additional burden on employers if an interim relief type remedy were introduced into discrimination claims is unlikely. But anyway, that's Steer and Stormshaw. And my second case then is the much publicised and controversial case of Forstater versus CGD Europe. And this, as I said, is an EAT decision. Now, Ms. Forstater worked for CGD Europe, which is an American-based think tank. She worked with them as a consultant until her contract was not renewed at the end of 2018. And it's a case all about what amounts to a philosophical belief under the Equality Act. Ms. Forstater holds the view that a person's sex is an immutable biological fact and is not the same as gender identity. She therefore believes that while a transgender woman can choose to identify as a man and ask others to identify her as a man, that person is in reality still a woman, even if legally their sex is changed under the Gender Recognition Act. And Ms. Forstater was quite a high-profile person and engaged in various social media debates on this topic, and her comments were found to be offensive by a number of trans people, and indeed by a number of her colleagues at CGD Europe who complained. And that led to an internal investigation, following which the employer decided not to renew her consultancy. Ms. Forstater claimed that this was discrimination under the Equality Act. She said her gender-critical belief was a philosophical belief for the purposes of Section 10, and so the non-renewal of her contract was direct discrimination. Now, before the tribunal, Ms. Forstater lost her claim, and that was because the tribunal said for a philosophical belief to be protected under the Equality Act, it had to justify the various criteria which are laid down by the well-known case of Granger in 2010. And the fifth of those criteria, known as Granger 5, is that for a philosophical belief to be protected under the Act, it must be a belief that is worthy of respect in a democratic society, and it must not be incompatible with human dignity or conflict with the fundamental rights of others. And the tribunal said that Ms. Forstater's belief fell down against Granger 5, against the Granger 5 criterion, although they were quite happy that the other criteria were met. They said it fell down against Granger 5 because it couldn't be a protected belief if it involved violating other people's dignity and creating an intimidating, hostile and degrading environment for them. And they were particularly concerned by the fact, as they saw it, that Ms. Forstater's belief was what they called absolutist, and it was a core part of her belief that she would refer to a person by their biological sex and gender as she saw it, and not by the gender they chose to identify with. And so the case went to the EAT when Ms. Forstater appealed, and again the EAT had to look at the European Convention on Human Rights. This time they were looking at Article 17, which is the article which stops someone from relying on a convention right, in this case, the freedom of belief that Ms. Forstater was relying on. But you can't rely on that right if you're engaging in the destruction of rights and freedoms of others. But the EAT said that this only disqualifies the most fundamentally destructive beliefs. Just because a belief is offensive or shocking to others does not mean that it should not be protected, they said. And so they said that it would only be beliefs that espoused hatred and violence in their most serious forms that might be disqualified from protection. Less serious forms of hate speech would not be excluded. And as far as Ms. Forstater's beliefs were concerned, the court said that they were indeed offensive to many people, but equally they were shared by many people in society. And so therefore the belief in and of itself did not seek to destroy the rights of trans people. So Ms. Forstater won her appeal, and the case goes back to the tribunal to be reconsidered. Now, the court was quick to point out, firstly, that they were not taking a position on the merits of the transgender debate, and equally that although the holding of a belief might be protected under the Equality Act, the way in which someone manifests their belief may still amount to unlawful harassment. For example, they said deliberately misgendering someone by not referring to them by their preferred pronouns may well constitute harassment under the Act. So we'll see when the case goes back to the tribunal whether in fact Ms. Forstater ends up winning her case, or whether the employer can show that what it did was due to the way that Ms. Forstater was manifesting her beliefs rather than the holding of the belief itself. But that, I think, shows the extreme difficulty for employers in knowing where to draw the line on these issues. We all know that diversity and inclusion is at the top of nearly every employer's agenda at the moment, and D&I training within firms is taking place regularly. And I think there's an assumption that most people hold the same views as we do in society. And people who do not and who espouse what we see as offensive views must be wrong, and they must be criticised and called out. And certainly I've seen that there's a risk of confrontation like that coming up in sessions such as a D&I training session. I think the Forstater case is a reminder that those other views may also be protected, and employers need to bear this in mind, and HR teams need to bear this in mind in their efforts to, quite rightly, create a more diverse and inclusive workplace. By definition, diversity of views means inviting views that some, or indeed many, may find offensive. However, where those views are manifested in a way that upsets others in the workplace, that is where an employer can take action and require employees to refrain from doing that, even if what they're doing is espousing a view that is protected in law. Easier said than done, I suspect. Anyway, that is Forstater and CGG Europe, a very interesting and emotive case. And that is the end of our podcast for this episode. I hope you found it helpful. As always, if you have any comments or questions, please do contact me. Otherwise, I hope everyone is still safe and well and stays that way until next time. And until then, goodbye for now.
So that concludes this podcast. We hope that you find it and others in the series helpful. If you have any comments or questions, or want to know how to claim continuing education credits, please email Christopher Fisher, Head of Mayor Brown's London Employment Team, at cfisher@mayorbrown.com. Thank you for listening to the podcast.